Greetings from Statue of Unity, tallest statue of world, and we all are proud of that statue. And before I go to the subject, this is my humble appeal. It was just 2 days back at Delhi also.
Respected seniors and dear colleagues, serving proxy for years together on this auspicious day, with folded hands and down head, I seek your guidance, blessings, and support to endorse my candidature for the post of proxy president year 2026, election year 2024. Consistently working for proxy and trying to visit even a smaller society and to assist our common proxy friends in any given situation, I have tried to serve proxy. I assure to serve proxy in the same way with the same zeal and enthusiasm. पथ का अंतिम लक्ष्य नहीं, सिंहासन चढ़ते जाना, लिए सभी को साथ, आगे है बढ़ते जाना.
So please endorse my candidature for post of President Foxy election year 2024. Election will be from 1st August to 10 August. So please consider my seniority, sincerity, dedication, easy to availability to any Foxian friends in any odd medical legal crisis. Please vote me, please support me. So today's subject for discussion, criminal liability in medical practice. So warm welcome all the delegates and wishing you a litigation-free practice. At the outset, I would like to thank DGF and Kanun Ki Pathshala Forum and Dr. Sarda Jain Madam and Sangeeta Madam in particular for inviting me to share my views about the subject. Usually I start any of my talk with this question: is it worth discussing? Yes. If it is yes, then why? Because medical litigations are increasing in number constantly and steadily, and unluckily we gynecologists rank first. And this is alarming statistic. Medical negligence cases involving surgery account for 80% of all cases, of which obstetrics and gynecology 29% top the list, followed by orthopedics 22% and surgeon. And hospitals are found to be negligent along with doctors in 34% of the cases. So this is statistic from court only, and we should be very careful. As far as criminal litigation is concerned, it is a major threat over and above civil litigation and litigation under CPA. Because as far as any civil litigation or litigation under CPA, we have enough time to respond. Notice is served, we reply notice, then court this in consumer fora trials runs, and ultimately results come. It could be in favor, against, but we have time. But as far as this criminal litigation part is concerned, suddenly investigating officer, police officer comes and say, doctor, you are under arrest. So we should be very careful in this situation not to end up into this problem. So as soon as any patient comes to us, and if we accept patient to treat, then it becomes a contract or implied contract between patient and ourselves, and it is a contract of personal services. We offer our expert services, and patient pays for that, or patient promises to pay for that. So it is a contract, and when contract becomes enforceable by law, it is a very important thing to understand. And as far as negligence is concerned, what is negligence? In our curriculum in forensic medicine, we were taught two words: act of omission and act of commission. Act of omission means not to do something which a reasonable prudent doctor would do. Say for example, if patient comes to you to take injection penicillin, naturally any prudent doctor would go with negative test dose, and then only he will go with full dose. And if full dose is given without any test dose, and if something goes wrong, it becomes a act of omission. Act of commission means doing something which a reasonable prudent doctor would not do. Say for example, if it is a planned surgery, and surgery is planned under general anesthesia, and patient has come with full stomach. Naturally, any prudent doctor would not go with general anesthesia on full stomach for any planned surgery. And if anybody does, then it becomes an act of commission. So to think simple things, act of omission and act of commission, we have to understand. And as far as negligence part is concerned, it is a breach of legal duty or care owed to the patient. What is legal duty? As soon as any patient comes to us and we accept to treat her, then our legal duty starts from that point of time. And we are owed to take care to the patient. And uh, if at all, if there is any problem and if patient suffers any damage, if it could be physical, psychological or financial, then it becomes a case of negligence. And legal duty stems from acceptance of duty in a legal way. And there are 4 ingredients of negligence. So which are the existence of legal duty? Sorry. Just I mentioned, as we accept patient to treat, our legal duty starts. Breach of that duty. If we do not perform that duty in a diligence way, then it becomes a breach of that duty. And one more ingredient, damage suffered by patient. If a patient suffers any damage, then it also becomes one more ingredient. And very important ingredient to prove negligence is doctor's conduct is direct and proximate cause of such damage. So action or taken on part of doctor should be direct and proximate cause for that damage which is suffered by patient. If these 4 ingredients are proved in court of law, then only negligence against any doctor can be proved. But very important question is, can doctor be prosecuted under negligence for negligence under section 304 and 304A Indian Penal Code? Now newer version is Nyaya Sangeeta section 106 and so. So let us discuss that. And these are some Indian Penal Code sections which were pertaining to our medical practice, and these were about damage to the human body. 304A, causing death by negligence. Section 336, act endangering life or personal safety. 337, causing hurt by act endangering life. This is simple hurt. Or section 338, causing grievous hurt by act, and section 312 to 316 and 318 related to miscarriages or abortion, and some more section 269 to 272, negligent act likely to spread infection or disease and danger to life of patient or life of any person. So these are some clause in IPC. Now they are in a newer version under Bharatiya Nyaya Sanhita. But let us discuss old one and then we will go to newer one. As far as section 302 is concerned, it is homicide. And in that very section, 3 things are taken into consideration: conduct, intention, and knowledge. So if anybody inflicts any injury to anybody with intention to cause death, then it becomes a case of homicide, that is murder, and triable under section 299 to 302 IPC. Now with newer version, some other section. Section 304, in this, conduct, intention or knowledge. In section 302, intention and knowledge. Here intention or knowledge. And in this 304, how investigating officer interprets that when you are going to go for any surgery, you know that death may occur. So you had knowledge of this conduct. So they consider that way, and section 304 may be applied, and it is non-bailable and triable in the court, and there is a provision of imprisonment for 10 years. One more section was 304A, that is conduct, no intention and without knowledge. When death occurs due to rash and negligence, then it becomes a case of 304A. So just I mentioned, the same thing is given here. With intention, imprisonment, punishment is imprisonment for life. With knowledge, if injury inflicts, say for example, if anybody inflicts any injury to anybody with knowledge that this injury is sufficient to cause death in ordinary course of nature, then it is triable under section 304 and provision of 10 years of imprisonment. And causing death by doing any rash or negligent act not amounting to culpable homicide, it is section 304A, and there is a provision of imprisonment for 2 years and fine, and it is bailable offense. So bail can be availed at police station level only. In section 304, bail cannot be availed at police station level, and bail can only be granted at honorable court only. But as far as section 304A is concerned, negligent act is not so severely punishable as an intentional act. If any act is done with intention to injure anybody or to cause death of anybody, then it is taken into seriousness and it is a serious matter. But negligent act is not so seriously punishable as intentional act. Most often applied in cases when patient dies as a consequences of and during medical treatment. So during treatment, if death of any patient occurs, then this section may be applied. And point in issue is whether doctor has taken adequate care and caution to prevent serious consequences of his action. This point is always taken into consideration at the time of deciding any case. And this section specifically tries to punish carelessness and negligence which has resulted into death. So can doctor be prosecuted for criminal liability is again and again question asked. And for that very important case, Jacob Matthews versus State of Punjab, which was decided in 2005, and in that very case, it is a landmark case as far as criminal liability during medical practice is concerned. But in the case of Jacob Matthews, background was one more case. It was case of Dr. Suresh Gupta versus Delhi High Court, and it was again decided in Supreme Court in 2004, and it was two judges bench, and this case was decided. Fact of the case was like this: death on table during surgery for nasal deformity. It was young patient with no any comorbidity or so, and patient was investigated and patient was taken for surgery for nasal deformity. Suresh Gupta is a plastic surgeon, and during surgery on table death occurred. Allegation was due to aspiration of blood, and which occurred due to cuff endotracheal tube which was not put in proper time, at proper place, or of proper size. It was the allegation on part of patient party. So at the time of deciding this case, magistrate and later on in High Court, because when this case was lost in first class magistrate court, it was challenged in High Court. But in High Court also, they made doctor criminally liable under section 304A. So appeal was preferred by Dr. Suresh Gupta in Supreme Court, and Supreme Court quashed the criminal proceeding. Why Supreme Court took this decision to quash this charge against Dr. Suresh Gupta? Suresh Gupta was free from his charge as far as Supreme Court's ruling and verdict is concerned. So observation on part of Supreme Court in that very case was, in the present case, even if argument of prosecution that aspiration occurred because cuff endotracheal tube was not put in proper time and place and of proper size was accepted to be true, then also he may be considered liable in civil suit for compensation only in civil suit or under CPA. due to lack of due care and precaution. But it doesn't make him criminally liable because act is not a reckless or gross. Here word gross was very specifically used, and to charge criminally liability, magnitude of negligence should be very gross and recklessness standard of care. So if negligence is of very uh, gross standard and recklessness standard of care, then only criminal liability can be decided. Otherwise, one can be tried for civil liability only. So with background of this case, in this Jacob Matthews case was further discussed and decided. In this case, patient was having a cancer and he had terminal stage, and as such no exact treatment for that very ailment was possible. It was only nursing care which was provided. So relative of that very patient, son particularly, requested hospital to admit him in the hospital to take care as far as nursing care part is concerned. So on request, patient was admitted in hospital, and when he suffered some heart problem, oxygen was applied, but ultimately patient expired during course of treatment, and case was filed. An allegation on part of relative was that it was lack in adequate supply of properly filled oxygen cylinder, which led to death of my father, and because of which patient died due to respiratory problem was one more allegation. So 304A was awarded by magistrate, and it is reiterated by High Court also in this case also. And in this case also, Jacob Matthews preferred appeal in Supreme Court, and again in Supreme Court, this case was quashed. And in this case, at the time of quashing this case, discussion on part of Supreme Court was like this: doctor was qualified and did his duty well. Oxygen cylinder not available or empty, hospital may be liable in civil law, but in this situation, doctor cannot be held liable criminally. And so section 304A was squashed in this case also. But point in issue at the time of deciding this case was this: is there a difference in a civil and criminal law in medical negligence cases? While dealing with cases of negligence in professionals, is there a need for judgment with a difference? These 2 points were taken into consideration at the time of deciding case of Jacob Matthews. So as far as negligence part is concerned, naturally either it could be civil or it could be criminal one. So difference between civil and criminal negligence was discussed during this case. So jurisprudential concept of negligence differs in civil and criminal law was the inference held by the court. What may be negligent in civil law may not be negligence in criminal law was the clear observation on part of Supreme Court. As far as civil negligence is concerned, court decided that simple lack of care is enough to prove civil negligence and sufficient to prove neglect of duty by probability of case also, and relief is compensation, and case is filed by an individual and violation of right in personam is the dictum. So as far as civil suit is concerned, compensation depends upon amount of damage suffered by patient. But as far as criminal liability is concerned, then punishment depends upon degree of negligence. If it is a high degree of negligence, then only criminal liability can be considered. And principle of vicarious liability do not apply in criminal cases. What is vicarious liability? So liability on behalf of subordinate staff by principal is a vicarious liability. So if at all anything goes wrong with your staff, you are vicariously liable for that damage suffered by patient due to action of your staff, that is vicarious liability. And as far as this criminal liability part is concerned, negligence has to be gross and high degree was again and again mentioned in that very case. Hence, 304A has to be read as a qualified with word grossly. If gross negligence is proved, then only criminal liability can be considered. And negligence by professionals, treatment with a difference. So at that point of time, at the time of deciding this case of Jacob Matthews, this was discussed. So court should ask that does that person possess skill he claims to possess, and how skill is decided. Skill is decided by degree. If you are postgraduate degree, diploma, DNB and OBGYN, it is presumed by law that you possess skill to deal with OBGYN patient. So here skill was discussed. Does he have requisite diploma or degree, just I mentioned, and did he exercise skill with reasonable competence? So ordinary skill is expected from court and no extraordinary or high skill is expected from court. And with this case, court has come up with 3 guidelines, and under these 3 guidelines, a further prosecution should be done by investigating officer. It was the mention. And as far as skill part is concerned, one more part was discussed, and that is care. And one should have taken reasonable care, not extraordinary care. So ordinary skill and reasonable care, if one can prove in court of law, he could be out of problem as far as any litigation, whether civil or criminal. So with this background, with these 3 guidelines were given by Supreme Court. Number 1, private complaint may not be entertained unless the complainant has produced prima facie evidence before honorable court in form of credible opinion given by another competent doctor to support charges of rashness or negligence against accused doctor. So it was very clear. There should be prima facie evidence as far as negligence on part of treating doctor is concerned. So it should be proved by credible opinion by equally competent doctor in this very case. And second guideline was, before proceeding against doctor accused of rash and negligence or act or commission, the investigating officer should obtain independent and competent medical opinion, preferably from respective department in government hospital, who is expected to be impartial and unbiased and who applies principle of Bolam test to the incident. So this was a second guideline, that independent and competent medical opinion should be taken by equally competent person from the respective department of government hospital, because it is considered as a impartial and unbiased. So what investigation officer should do? He will collect all the papers of treatment given from the hospital. He may take statement of doctor and he will submit that paper in respective department of nearby medical college, and he will ask opinion from that very department. Is there any prima facie negligence on part of treating doctor in this particular case? And if there is no opinion about prima facie negligence case, then police will file C summary and case will be closed at that point of time. If there is an opinion that it seems to be prima facie negligence on part of treating doctor, then only investigating officer will proceed further with investigation and he will put case in honorable court. Third guideline was given, that doctor accused of rashness and negligence may not be arrested in a routine manner unless his arrest is necessary for furthering the investigation or collecting evidence, or officer feels the doctor may not make himself available to face prosecution. So if at all investigating officer has any presumption that doctor will not be available for further investigation, then only he can arrest, but not in routine manner. He cannot put handcuff or so. So it was also mentioned in this guideline by Supreme Court in Jacob Matthews case. And one more case was decided, Martin D'Souza versus Muhammad Ishfaq, and it was decided again in Supreme Court by Justice Kaju, it was also a very interesting case. Why this case is landmark case? Justice Kaju has stressed importance of expert opinion in medical negligence case at the stage of admission of case itself. So same thing was stressed by Justice Kaju at the time of deciding this case of Muhammad Ishfaq, that there should be prima facie negligence on part of treating doctor, and there should be non-biased opinion from equally competent person to further investigation or to take any action against any doctor. So Justice Kaju also endorsed the same observation which was made by Supreme Court in Jacob Matthews case. As far as this Muhammad Ishfaq case is concerned, case was like this. Patient had a urinary tract infection and he was treated by amikacin and Mendelin. And after some time, patient absconded from the hospital against medical advice, and at that time he was advised to stop amikacin injection. But he didn't take it seriously. He continued amikacin and came with complaint of hearing problem. And he had filed a case. An opinion from expert from AIMS was taken at the time of deciding this case. An opinion from doctor from AIMS was amikacin is life-saving and cannot alone cause a hearing problem. There could be some other reasons also. So there is no negligence on part of treating doctor. But in this case, National Commission didn't take into consideration opinion from expert from AIMS, and they awarded compensation of rupees 12 lakhs in this particular case. And then after, this case was decided in Supreme Court. So just I mentioned what was the fact of the case. So in this case, when he was awarded with 12 lakhs of compensation by lower court and then National Commission, he preferred appeal in Supreme Court, and this case was against Justice Kaju. So in this case, observation on part of Supreme Court was patient took discharge from hospital by his own against medical advice and continued amikacin in spite of verbal advice to stop during follow-up visit, and amikacin was life-saving, which was more important than hearing impairment. This was observation on part of Justice Kaju at the time of deciding this case. An expert affidavit should have been taken into consideration, which was not taken into consideration by lower court. But Justice Kaju stress upon this, that courts are not expert in medical science, so they should consider expert evidence or expert affidavit into consideration. So in this case, there is no negligence on part of treating doctor, and all the charges against a doctor were squashed in this very case. And at that point of time, there were some observation on part of Justice Kaju was law is watchdog and not bloodhound. So if reasonable care is taken by doctor, will not hail him negligent, so doctor need not to worry. And Bolam test should be used while fixing medical negligence, and doctor is expected to have ordinary skill and he should have taken reasonable care. And courts are not expert in medical science. So it was observation on part of Justice Kaju, and he also came with all the guidelines, all the three guidelines which were given in Jacob Matthews case, but he added one more. If police or investigating officer has over-exercised power, then police is also liable for punishment. It was by Justice Kaju. And I would like to mention, at the time of this case, when this case was decided, before that case decided, there was a national conference on medico-legal issues at Pune, and Justice Kaju was invited as a guest speaker. And in a leisure time on table, coffee table, we were discussing, and he tried, we were never knowing that he is going to decide this case in future, but he was very interested to discuss with us what is negligence, how usually you take care of patient, you are treating any patient. If patient doesn't follow your instruction, then what you do. So he discussed each and every point related to that very case with us at the time of this conference of Pune. And after 15 days or so, this judgment came, which was very doctor friendly. So as far as legal opinion part is concerned, if there is any apprehension of being prosecuted criminally, call your colleague and family friends and manage for bail. Because usually what happens, if section 304A is applied by police, it is bailable on police station level only. So you can avail bail from police station only. But if you have apprehension that police may apply section 304, then naturally you should go for anticipatory bail, because if you are arrested, then police may take you to honorable court and only court may grant bail. And if police wants to harass, they may arrest on Friday evening, and Saturday, Sunday courts are closed. You will have to be behind bar in police custody during that very period. So it is very important thing. And always insist for post-mortem examination whenever you are facing this type of cases. As far as criminal part is concerned, usually in case of death, these are the potential cases as far as these litigations are concerned. So always insist for post-mortem examination in cases of sudden death on table or obstetric or any mishap, because whenever, of course, many a time we have exact cause of death to declare, but even then, if you can manage for post-mortem examination, it will endorse your judgment. Then never succumb to demand on part of relative not to undergo post-mortem examination. Many a time, patient's relative will give in a writing, ready to give in a writing, that we do not want to go for post-mortem examination and we have no objection against doctor or hospital. But in this situation, this type of writing doesn't give you immunity in court of law, because after going home, they may sue and they may issue a notice also. So never succumb to this type of request when there is a sudden death on table. Always insist for post-mortem examination, and your role is only to inform police. Your onus to explain to the relative of the patient is on shoulder of police only. You have to inform police. You have not to convince relative to go for post-mortem examination. So, but in this situation, many a time, if it is a very known family and if there seems to be bona fide one, then many a time once we advise or insist for post-mortem examination, many a time they may be instigated to charge a case against us. So in this situation, we have to tackle it very tactfully. After informing police, we can have a discussion with relative, but we have to explain about importance of post-mortem examination to know exact cause of death. As far as MTP Act 1971 is concerned, it is also act and triable with criminal liability. So center not registered under MTP Act, person not qualified, and consent is not taken in Form C. These are the three areas as far as services of abortion are concerned, and you are criminally held liable, because to terminate pregnancy at unregistered place or even at registered place by unqualified person, there is a provision of imprisonment of 2 years to 7 years, and it is triable in criminal cases. So we should be very careful. And one more very important area, and that is consent. So under MTP Act, we have to take consent in prescribed form, that is Form C. Of course, we have to go with one more consent, that is informed consent, because in Form C, it is a very simple consent. I give my permission to doctor to terminate my pregnancy. This is very simply written in Form C. So it is not informed consent. So you will go with two consent. Informed consent, which we usually take in our routine surgery or so, and consent in Form C. But consent taken in informed consent cannot replace consent to be taken in Form C. So you are under obligation to take consent in Form C. And why I am stressing again and again, because in this situation, if you have not taken consent in Form C, then under Indian Penal Code, even today,
please mute yourself, all of you.
so under this Indian Penal Code section, to terminate pregnancy is criminal offense even today. But this is umbrella for us. Medical Termination of Pregnancy Act 1971 allows termination of pregnancy by medical doctor with specialization on certain grounds. So it was very specifically mentioned in MTP Act under section that notwithstanding anything contained in Indian Penal Code, a registered medical practitioner shall not be guilty of any offense under code or any other law time being in force if pregnancy is terminated by him in accordance with provision of MTP Act. So here what accordance is very much important. So if you have terminated pregnancy in accordance with provision of MTP Act, then only you are out of purview of Indian Penal Code section 3012 to 312 to 316. So we should practice abortion services only under strict provision of MTP Act 1971. And as far as this act are concerned, this is section 312, causing miscarriage with or without consent of pregnant woman, and provision is 3 to 7 years of imprisonment, and both are considered guilty, doctor and patient both. Under section 313, causing miscarriage without consent of pregnant patient, and provision is 10 years of imprisonment. And if you have not taken consent in Form C, then investigating officer will apply this section, section 313, causing miscarriage or doing MTP without consent of patient. So we should be very careful. With very important sentence of whole of my lecture today is this: take consent in Form C in case of termination of pregnancy. Section 314, act with intent of causing miscarriage resulting in death of woman, and section 315, act with intent of causing death of unborn child or causing child to die after death, and section 316, act to cause death of pregnant woman resulting in death of unborn child. So not to enter into 302 to 316 Indian Penal Code, we have to practice abortion services under strict provision of MTP Act. As far as PCPNDT Act is concerned, again it is also criminal act, and in this also there is a provision of imprisonment, and we should be very careful, because under PCPNDT Act every offense shall be cognizable. Cognizable means investigating officer may take cognizance of offense, and without permission of court he may investigate investigation. It is non-bailable. Bail cannot be granted at police station level, and one can avail bail from court only, and it is non-compoundable. Once case is lost, case cannot be withdrawn in between. Result has to come. It could be in favor, it could be against, but it is non-compoundable. So we should be very careful as far as this PCPNDT part is concerned. So centers should be registered, person should be qualified, and if you are dealing with non-invasive procedure, that is sonography, etc., then your center should be registered as a sonography center. If you are interested to go with invasive procedure under PCPNDT Act, say for example amniocentesis, chordocentesis, choriovenous sampling, etc., then your center should be registered as a clinic, and this invasive procedure should be allowed under registration or certification of registration. So this is very important part. Second part is qualified person can only do sonography or invasive procedure. And as far as record part is concerned, very important record is register, that is under rule 9 sub rule 1. you have to maintain registered with 4 columns: serial number, name and address of a patient, name of spouse or father, and date on which patient uh, uh, referred to go for sonography or invasive procedure. So with this 4 column, you have to maintain register. And as far as different forms are concerned, Form F for non-invasive procedure, Form G for invasive procedure, and all these records are to be maintained and to be preserved for 5 years, because breach of any of this may invite litigation. And even if you have not done any sex determination, but if there is a inaccuracy in record under section 4 subsection 3, you are triable criminally also, and court may award imprisonment for 6 months to 3 years or so. In few of the cases it happened that merely on this ground of clerical mistake, our Foxian friends were awarded with imprisonment for 6 months or 1 year. But we were lucky in 3 cases. I was their legal counsel after this punishment happened, and we preferred appeal in higher fora, and in higher fora all 3 doctors made free and they were out of criminal charges. So PCPNDT part is concerned, we should be very careful as far as record keeping and preservation of record is concerned. One more area as far as criminal liability is concerned, never detain patient for recovering the fee. You cannot detain patient merely for recovering the fee, because you may invite section 340 of Indian Penal Code and it becomes a wrongful confinement, and there is a provision of 1 year imprisonment and or fine of rupees 1000 or both. And these are some other section as far as criminal liability is concerned. Section 172 to 190, absconding to avoid service of a summons. If you are served with a notice from court, summon from court, and if you do not honor, then all this section may be applied, preventing services of summons or other proceeding. So this is a long list, we do not go into detail, but whenever we are served with a notice from court, from patient, from advocate of patient, we have enough time, and we may ignore also, but it is not advisable to ignore. Legally you are not challenged, but if you ignore this type of notice, when they prefer appeal in court or so, first inference may go that doctor was not serious to reply even notice. So even if it is served by patient or advocate of patient, though it is not mandatory, but notice should be replied. But if it is served from court, then we are under obligation to reply well in time with all evidences of treatment given. Otherwise, decision may come ex parte. So this is very important clause. One more area, giving false evidence or giving false certificate, it becomes a fabrication of evidence, and this is again criminally liable under section 191 to 223 Indian Penal Code. So whenever we are issuing any certificate to any patient, we should be sure that whichever certificate we are going to issue is true, and no false certificate should be given to the patient. And one more area, no certificate should be given in post date. Patient should be before you only at the time of issuing certificate on that very date and time. Because in one of the cases, it was happened, one employee was working in electricity department. He was absent for 2 to 3 days from his services, and his salary was with him. He went to medical officer in primary health center, and he asked for certificates that I was not well and I didn't attend my duty for these 3 days and my salary is held. If you can give me certificate that I was under your treatment, then my salary can be released. And for no consideration, doctor gave in good faith certificate that he was under my treatment for these 3 days. But unlucky on part of that doctor, that very person was under custody in police station of another town for that particular time. So of course with certificate his salary was released, but when electricity department came to know that it was fake certificate, they filed complaint against that person, that is their employee, and that doctor too. And it was very difficult for that doctor to face in court of law. So in this type of situation, we should be very careful. And as far as guideline on part of National Medical Commission, whenever we issue any certificate to any patient, two identification mark should be there, and preferably thumb impression, that is right and thumb impression of that very patient. So we can prove that thumb impression of that very patient I was examined by me, and I have issued certificate to that very person only. Because if at all they have given fake information, then also you are saved in court of law. Of course, in doubtful case, you can ask for any ID proof, but in few of the cases, it is also observed they have produced fake Aadhaar card. Of course, you can verify on online, but whenever you are taking this type of certificate from any patient, have a signature of patient. That certificate should be attested by patient only. One more area, disappearance of evidence. So if you disappear any evidence, then also it becomes a criminal case under section 201 and 204. Say for example, if it is a minor patient and if you have terminated pregnancy, you are under obligation to inform police and preserve product of conception in saline, and it is to be handed over to the police. If you have not preserved product of conception, or if you have not handed over product of conception to police, then it becomes a case of disappearance of evidence, and you may invite litigation criminally. One more area, act likely to spread infection. So here comes biomedical waste disposal, and we should be very careful in this, because if at all it is proved act likely to spread infection, you may be triable under section 268 to 278 as far as criminal part is concerned. And adulteration of drug, if you are dispensing drug to patient and if it is adulterated and if it is proved, then again you will be held liable criminally. So these are some criminal liability as far as our medical practice is concerned. So to conclude, this gentleman have so many staircases, but he doesn't know how to use them. It doesn't matter how many resources you have. If you do not know how to use them, they will never be enough. There are so many provisions in law in our favor as far as medical practice is concerned. There are so many judgments in Supreme Court and in Honorable High Courts in our favor. But if you do not know them, then they will never be useful. So have some basic legal knowledge and always obtain medical legal advice whenever you are in doubt. So to conclude, if you want to sleep like this, take tender care of your patient, comply with the provisions of law and land of law, and pray Almighty God before going to sleep, and keep my visiting card below your pillow. And this is a leopard behind innocent gynecologist, a leopard of law, and see the role of medical legal, how he can be useful in this type of situation. So please do not hesitate and have a phone call to medical legal expert in this type of situation. So God bless you. Have a litigation-free medical practice. With regards, salute to organizers. And again, my humble appeal, wherever you are, I will be there. Promise to reach the unreached. Seeking your vote and support in my endeavor for election, President Foxy, election year 2024 from 1st August to 10 August. Thank you very much. Please do not assume. Please ask if any query, any question, if chairpersons and time permits. Thank you very much.
Thank you, sir.